Government Operations. It's Tuesday, July 6th, and we're here today for a virtual hearing on docket 0654, ordinance amending CBC Chapter 813, ensuring equitable regulation on the cannabis industry in the city of Boston, and docket 0655, an order regarding a text amendment to the Boston zoning code with respect to marijuana establishments. Both were referred to the committee on May 12, 2021. I happen to be the sponsor of both dockets, along with Councillor at Large Michael Flaherty. In accordance with Chapter 20 of the Acts of 2021, modifying certain requirements of the open meeting law and relieving public bodies of certain requirements, including the requirement that public bodies conduct its meeting in public place that is open and physically accessible to the public. The City Council will be conducting this hearing virtually via Zoom. This enables the City Council to carry out its business while adhering to public health accommodations. The public may watch this working session via live stream at www.boston.gov/city-council-tv and live on Xfinity 8, RCN 82, Verizon 964. It will also be rebroadcasted at a later date. Written comments may be sent to the committee email at ccc.go@boston.gov and will be made part of the record and available to all councillors. Quick summary, and again, for those who are maybe just joining, I am going to do a quick summary, then turn this over to Leslie. She will only be able to be here till 12 o'clock. And then I'll have councillors go. And then Chris English from ISD can testify. And then we will do a round if need be, and then get to the public. Docket 0654 is proposed ordinance that would amend the current cannabis ordinance by removing the Zoning Board of Appeals from the process. The proposal codifies the half-mile buffer zone and maintains the objective that no one area of the city will have an over-concentration of cannabis businesses. The ZBA, we find, is no longer needed because of the creation and jurisdiction of the Boston Cannabis Board. The proposal also clarifies that the dispensary is the entity that will go through the community process when it comes to deliveries. The proposal includes conflict of interest language and application requirements. The text amendment proposes to make cannabis establishments an allowed use and prohibits cannabis establishments in residential districts, or it makes it a forbidden use in residential districts. These dockets will remove the Zoning Board of Appeals from the process and will provide consistency in the cannabis industry by having the Boston Cannabis Board as the entity with regulatory and citing authority. We are here today. Again, my name is Councillor Lydia Edwards. I'm joined by Councillor Ed Flynn and Councillor at Large Anissa Sabi George. We're going to now turn it over to Leslie, as I stated, who is here on her vacation. She will testify. Then we'll go back to councillors. Leslie Delaney Hawkins is a member of the Boston Cannabis Board, is the administrator of the Boston Cannabis Board. I'll let you go ahead, Leslie.
Thank you, Councillor, and thank you for having me again. I apologize. I am on vacation, so that's why I'm only here for the start. But if there are any questions, I'm happy, after I'm gone, I'm happy to schedule time to talk through those. So obviously this body actually created with the former mayor, the Boston Cannabis Board as the citing authority for the city of Boston. So I'm the executive secretary, so I'm the keeper of the records, the administrator, and the serve as the attorney for the board. So I'm just going to give a quick overview of how the board is comprised, what our process currently is, and then any questions or anything the members of the council would like me to touch on further. So this is a 5-member independent board that is appointed to 2-year terms, each member. Each member has a very specific area of expertise pursuant to the ordinance. So there is always a commissioner, and in this case, our chairwoman, Kathleen Joyce, who has licensing experience. There's an individual with public health experience, an individual with public safety experience, community organizing experience, and labor experience. And the thought there is to ensure that all of these individuals can bring their own unique perspective to evaluating the proposed sites for these cannabis establishments. For example, when we're looking at security and operations plans, Commissioner Lisa Holmes, who's a former BPS superintendent, brings her experience to the table. When we're looking about the regulatory and some of the licensing pieces, Chairwoman Kathleen Joyce brings her area of expertise. So it's actually been very interesting to see how each individual brings their background to the table. So the current process for someone looking to cite a cannabis establishment in the city, and I'm sorry, let me just back up by saying This board is tasked with ensuring equity in the cannabis industry, not just in to whom these licenses go to, but as Councillor Edwards said, in the geographical distribution of these licenses across the city to ensure that we are operating and citing these in keeping with the goal of the ordinance, in both equity in terms of the licensees themselves, but also the locations. So we don't see in Boston what has happened in some other cities across the city where you see what's called a green mile, or where one neighborhood or one area is where all of these are cited. And obviously the spirit of the half-mile buffer zone in the zoning code also was seeking to accomplish that goal. So currently the process, if you're looking to cite a cannabis establishment in the city of Boston, you file an application with the Boston Cannabis Board, and that includes all of your disclosures, what you're proposing, your security and operations plan, and you file with ISD for the underlying use, because as everyone knows, there's nowhere in the city of Boston presently where cannabis is an allowed use. So there's the way the zoning code is written right now, you will always need zoning relief, even if you're not discussing the half-mile buffer zone. So you move through the process after filing with the Boston Cannabis Board and ISD. You have your statutory required community meeting. We obviously always encourage applicants to do more than the bare minimum when they're working with the community, but under Massachusetts general law, in order to even be considered for a host community agreement, that statutory meeting has to happen. So once you have your community meeting, you then request a letter of support, opposition, or non-opposition from your district city councilor. As all the members of the council know, that you have 45 days from that date for the councilor to take a position, which can always be supplemented at the hearing. Once that letter is received, your application is deemed complete. If you are an equity applicant, you move to the front of the line in terms of scheduling. If you are non-equity, you are placed in the queue to be paired with the one-to-one equity to non-equity ratio. Currently, we have about approximately 17 non-equity applicants dating back 2 to 3 years who are waiting to be paired. And we have a number of equity applicants that are in various stages of the process, from just filing to scheduling the community meeting to waiting on a position letter from their district city councilor. Once you are heard by the board at a public hearing, if you are granted a license by the BCB, you will then be scheduled for a zoning board of appeals hearing. When the BCB is evaluating each application, each commissioner applies the very specific criteria that is established in the ordinance. And obviously, we make that public. The scoring sheet that each commissioner uses as a guide is on our website. We share that with applicants. And there are very specific criteria that the BCB evaluates in determining whether an application is appropriate in time, place, and manner. If there is an applicant who is applying for a site within the half mile, the board actually, in its rules and regulations, understanding that under the zoning code, the only relief available to cite two establishments within a half mile is a variance. So the BCB's rules and regulations actually mirror the legal standard for a variance that would be applied by the ZBA in its respective process. So when this board is looking to cite an additional cannabis establishment, when there's already one within a half mile, it applies that heightened level of scrutiny. And currently any granting of a license would be conditional on that applicant receiving the required variance from the Zoning Board of Appeals. If you are granted a license, whether it's conditionally or otherwise, and you are subsequently granted relief from the Zoning Board of Appeals, you then move on to the state process. So you cannot go forward with the Cannabis Control Commission. And if there is an application, they actually reach out directly to the BCB in writing and request a municipal response notice, where we have 60 days to say this applicant is either in compliance with all of the requirements of Boston as a municipality, including zoning, or it's not. And if someone has not yet received zoning relief or they're denied zoning relief, then I inform the CCC that they're not in compliance, and then they do not move forward with being evaluated at the state level. One thing I just wanted to flag, because I know Councillor Edwards, her district was one of the first where delivery was even being contemplated before any of us really understood, and before the CCC had actually promulgated the final two delivery types and the regulations for those. So there are two types of cannabis delivery. The first is courier only, and that is kind of the Uber Eats of cannabis, where it is an approved cannabis delivery operator that is picking up from a dispensary and delivering directly to consumers. There is no warehousing component. So while they will have a base of operations, there's never any cannabis at that site. It's where their vehicles are stored. It's where they dispatch from. The second is the wholesale model, and what that allows an applicant to do is to obtain product at the wholesale level, warehouse it in what's called white label, which is rebranding. So if it would be Leslie's wholesale delivery company, I could pick up from wholesale at my approved warehouse site. I could then rebrand it, and then I could deliver direct to consumers. There's no retail component at the site of either of those. The biggest concern, I think, and that we'll see, I shouldn't say the biggest, but a significant concern that I don't think the CCC understood that was going to have an impact in Boston, is that currently the municipality does not have any control of delivery courier operators coming to one of our approved cannabis establishments and delivering directly to consumers. So the example that we're currently dealing with is if somebody wanted to come into Berkshire Roots in East Boston, pick up product there, and then deliver directly to consumers, if that business is located outside of the city, the board and the city have no jurisdiction over regulating those. So the board recently held a public comment period to actually require that the cannabis retailer itself will need the board's permission to engage in delivery with the approved delivery operator. And that was so that the board would have some ability if, let's say, Berkshire Roots were to be approved, and we get calls from the councilor's district saying that, well, they're double parking, they're blocking the street. Now the BCB actually has some regulatory authority to say you can't continue operating that way. And the other thing that, and this actually came from Councillor Edwards and from the council early on, is that we do not apply the one-to-one equity to delivery operators, because for the first 3 years of delivery, it is only accessible to economic empowerment and social equity applicants, which effectively means that the goal is for equity to be the focus of delivery. But when we're talking about pairing the one-to-one, we didn't want to see all of the equity applicants are delivery, and then all of the non-equity are brick and mortar retailers, which obviously is a much higher barrier to entry in terms of opening, but also very different in terms of potential profit. And then the one thing, and then I'll stop and can explain anything further, but that I know we've had a number of conversations about, is when we're looking at the one-to-one equity and non-equity ratio, should there be exceptions for certain license types? And again, we're just the regulator, so we're just kind of expressing things that we've seen come up. For example, we have a lab applicant who is still in the queue and has been for over approximately 2 years. They're non-equity, but we don't have any other lab applicants in the entire city. And there's also a shortage of labs statewide. So again, this is nothing that the board takes a position on. This is simply flagging kind of potentially unintended consequences or effects that none of us could have foreseen when we were starting to get this emerging industry up and running. So again, that's kind of an overview of what our process is at the BCB. All of the scheduling is based on gates, and then the equity to non-equity one-to-one ratio. So we do not take somebody out of line, with the exception of potentially having a conversation about uses such as laboratory, but that would be a directive we would be looking for from the council and the administration. So that is kind of my not so brief overview of what the process is right now.
Thank you very much. We've also been joined by the co-sponsor of these dockets, Councillor at Large Michael Flaherty. Councillor Flaherty, we let Leslie go first because she's on vacation. She also broke her foot and she has a very limited time frame. So we went ahead and just went to her. No one has given any introductory remarks. So I was going to now do introductory remarks from councillors, and then Chris English would testify. Councillor Flaherty, is that okay?
Yeah, that's perfect, and well-deserved vacation, and good luck and hopefully a speedy recovery. Madam Chair, would you like me to do introductories at this time?
Yes, we co-sponsor if you'd like to go, or I can come back to you after we, Councilor Salvatore George.
Yep, thank you. No, that's fine. No, that's good. I just had some difficulty getting on, so thank you, Chair, for pulling this together, and also for the members of the administration, Leslie and others that are here with us
Councilor
today.
Flaherty. Councilor Flaherty, I think
Lead sponsor of the buffer zone
on my
amendment.
end,
The
Councilor
intention of the
Flaherty.
buffer zone amendment was to prevent the clustering of cannabis facilities and to ensure that they would be spread equitably throughout the city. And yes, I can hear you, Madam Chair.
Yeah, the
I
connection.
don't know if that's better. Is that better, Lydia?
I think so. Yes, I think it's better.
I'm going to reboot it.
Did he leave? Is he still there? No.
I think he jumped off.
Counselor Edward, Christine, I think he said he was going to reboot.
Okay. All right. Let's just go to the other counselors, and we'll start with Counselor Flynn, then Counselor Asabi George, then I'll go, and then we'll see if Counselor Flaherty's back.
Thank you. And thank you, Counselor Edwards, and thank you, Counselor Flaherty as well for putting this ordinance and zoning amendment and having this working session. I also want to say thank you to Leslie Delaney Hawkins and Chris English as well for being here. And as I said at the beginning, I hope Leslie is feeling better after her ankle. So hope you're feeling better, Leslie. So ensuring that we have a fair and equitable process for approving cannabis dispensaries is important. And we also need to ensure that this process allows for full community input. I have received emails from Chinatown residents recently who have expressed concern about the proposed ordinance and zoning amendment. They have noted that Chinatown is a small residential sub-district and that many residents live in areas that are not zoned as residential, and that there are many daycare centers that might not count as educational facilities. This is common in my district, especially in many immigrant communities as well. But again, I'm here to listen about this ordinance and amendment and how it can, and how the process will continue and the impact it will have on neighborhoods. And I also, just for the record, just want to mention that we had a controversial hearing recently at the ZBA and on cannabis on K Street. It was voted, the ZBA voted against it, and all of a sudden they're doing a revote for some technical reason. And my residents, my constituents in South Boston are very concerned about this revote. So maybe if Chris has an opportunity to answer that question, you know, if the ZBA votes on an issue and then someone wants to do a revote, you know, you just can't do it because you lost the game. You know, if the Bruins lost in the playoffs game, in the seventh game, you can't say, well, let's do a regame. Let's have another game because we lost. So you probably can sense my frustration about it. But more importantly, my residents, my constituents are not happy about it either. But again, just want to say thank you for Councilor Edwards and Councilor Flaherty as well. And thank you to Leslie and to Chris English.
Thank you. We'll go to Counselor Asabi George, and I see we've been joined again by Counselor Flaherty.
Thank you, Madam Chair, and thanks to the lead sponsors for today's conversation effort that's underway. I don't have much for opening statements other than just very interested in today's conversation and how we can improve this process going forward. Thanks, Madam Chair, and thank you, Chris and Leslie, for joining us. And just a special note of thanks to Leslie, especially as she's on vacation. Thank you.
Counselor Flaherty.
Thank you, Madam Chair. Hopefully that is better. And thank you to the members of the administration, Leslie, Chris, and Chantel, who are my colleagues who are here. As the lead sponsor on the buffer zone amendment, the intention of the buffer zone amendment was to prevent the clustering of cannabis facilities and to ensure that they were spread equitably throughout the city. Currently, we have both the Boston Cannabis Board and the Zoning Board of Appeals weighing in on the process, which I think leads to considerable unpredictability, particularly at the ZBA, where they don't always adhere to local zoning, as well as the lack of clarity for residents and proponents alike. So it's unclear to many, including myself, how the buffer zone is weighed throughout the BCB process, if at all. That needs to happen, and also how it's weighed at the ZBA, which it's been inconsistent. So, and I think we've seen we received a letter, I think, from one of our colleagues, the Chair Ways and Means, citing some of those examples in her district, just again in the inconsistency and the unpredictability. And at the end of the day, we want predictability of process for the proponents and their investors, but also and the landlords, but also we want it for the community and the abutters. So if we're going to fully empower the BCB to make these decisions, I just want to make sure that we're doing it with clear criteria that we anticipate and fully expect that the buffer zone will be respected and applied, and also looking forward to hearing the testimony, as part of a robust legislative process. So I appreciate Madam Chair's partnership, obviously, and look forward to bringing more clarity, more predictability, and more transparency to the process. Thank you.
Thank you. So I have two letters from colleagues who couldn't be here today. I'm going to read them into the record. The first is from City Councilor at Large, Julia Mejia. Dear Madam Chair, members of the Committee on Government Operations, I'm writing to inform you of my absence at today's hearing on the Committee on Government Operations on Docket 0654, Ordinance Amending CBC Chapter 8-13, ensuring equitable regulation of the cannabis industry in the City of Boston, and Docket 0655, an order regarding a text amendment to the Boston Zoning Code with respect to marijuana establishments. Due to a previously scheduled engagement, I will not be sitting in. As the chair of small business, ensuring that we are creating systems for equitable access to cannabis establishments is key towards addressing the fundamentally racist war on drugs. We will follow along with interest and follow up as necessary. Sincerely, Julia Mejia, Boston City Council at Large. And then from Councillor Bach, she asked that I read her letter in its entirety into the record. Dear Chair Edwards and Councillor Flaherty, I regret that I'm not able to attend this morning's hearing, although a member of my team will be watching and making detailed notes. Thank you for raising this important issue of the interplay between the Boston Cannabis Board and the Zoning Board of Appeals in the citing process for cannabis establishments. I want to stress that my constituents in District 8 regard the half-mile buffer as an important piece of achieving an even rollout of this new industry across the city, rather than following the default economic pattern of clusters in just a few neighborhoods. A number of the communities I represent are denser with residents than any other part of the city, yet are often regarded as commercial zones by those who live further outside of the center. As the counselor to these downtown neighborhoods, it is important to me to represent their voices in this process. I emphasize this point because while I have been seen the Boston Cannabis Board do remarkably thoughtful, equitable, and diligent work in grading applicants according to the criteria set forth in the ordinance, I have not seen it apply any substantially higher bar to applicants who fall within the half-mile buffer zone of another cannabis retail location. By my observation, it has delegated the issues of appropriateness of citing, and especially the ramifications of the half-mile rule, almost entirely to the Zoning Board of Appeals. My constituents in the Back Bay have seen 4 locations, all within the same buffer zone, go to the BCB and all be approved, with arguments related to the buffer zone appearing to not weigh meaningfully in the balance. The ZBA rejected one of these locations, sandwiched between 2 residential buildings last month. But the decision of the BCB to let the application even proceed to that point, despite the challenges of the site and the half-mile rule, was of great frustration to many of us. Therefore, while I agree that the Zoning Board of Appeals does not have the same specialization in the cannabis industry as the BCB, and that the BCB would be better, more informed authority to consider not just the operator of their plans, but also the citing and the half-mile rule, I could only support the reassignment of responsibility proposed in this ordinance if we also established clear criteria by which the BCB would need to evaluate citing appropriateness and clearly higher bar, and a clearly higher bar for any exception to the half-mile rule. Otherwise, my concern is that citing appropriateness and half-mile rule and being removed from the jurisdiction of the ZBA would be removed from consideration altogether. Again, I apologize for being unable to make this morning's hearing, and I look forward to a future working session. And then I'm going to go very briefly and turn it over to Chris English from ISD. So again, I'm the lead sponsor along with Councilor Flaherty on this matter. And I wanted to, this was inspired by the fact that my district has been the first and often been on a back and forth inconsistent understanding of how to deal with cannabis. When we had to deal with the ZBA and the half-mile buffer zone, we ended up with one of the applicants who's still in the process trying to get his, a local applicant from East Boston, still trying to get his cannabis license from the state and through this process, while a corporation, Berkshire Roots, was able to just walk in and take advantage, I think, of honestly inconsistent rules and lack of clarity. And by virtue of the fact they stood in line on the same day at the ZBA is the reason why one applicant, an Iraq veteran, a Latino man, born and raised in East Boston, is still waiting to open up his cannabis establishment, and the corporation is fully open and making money as it is right now. So, and I find that frustrating because the ZBA really didn't weigh anything else. They literally let one go through and then held up the buffer zone to the other. Another example of frustration of the process and the industry kind of getting ahead of clarified process is when we were dealing again with the same corporation, and they wanted just simply to have a delivery. And they had a delivery company come in, and that delivery company, having been unaware of the promises made by this corporation to not have and use a certain loading area behind them, the delivery company just simply presented themselves to the community and was then ripped apart. And I found that to be disgusting on the part of the corporation to set that business up. And I also said it didn't make any sense that a delivery company should be going through their community process at every single site that delivery company wants to deliver. If you have the money and you are physically there as a huge corporation and as a dispensary, and you want to add to your business opportunities, then you should do the community process and you should present that to the community. And that's what also this is proposing. At the end of the day, the Boston Cannabis Board did not exist when we had legalization of marijuana, and that's why the ZBA ended up in this conversation to begin with. And that is why, as Councilor Flaherty noted, he had come up with a half-mile buffer and text amendment to make sure that there was no concentration of cannabis industry or dispensaries in any one neighborhood. The entire city of Boston overwhelmingly voted to legalize cannabis. That is a fact. And so the entire city of Boston should have both the benefits, burdens, and whatever that comes with a new industry. And we also believe, quite frankly, we are tasked by the state to make sure it is as equitable as possible and to undo a lot of the harms done by the war on drugs, specifically with this particular product. So I'm here, we propose two ways to remove the ZBA. The first is the zoning amendment itself, as people mentioned. It's based on the text amendment, and it would basically make, it would still have cannabis as a forbidden use in residential areas, but it would be allowable use in commercial areas. And it would take out the half-mile buffer zone in the zoning. The half-mile buffer, however, is put back in the ordinance that controls the BCB, the Boston Cannabis Board, and that is also what we are proposing an ordinance that one deals with the issue of the delivery and the one-for-one and making sure deliveries and dispensaries are not considered the same for the equity applications. It strengthens the conflict of interest, disclosure and ethics provisions for the board members. And it does codify the half-mile buffer zone. And it will still allow for, again, community, still allowing for exceptions to that with community support, special circumstances statement, proximity of hardship exception, a statement on that, and a negative impact statement. So happy to beef up what those standards are for granting an exception to it. I understand quite firmly, and I believe quite firmly that we don't want a concentration of this industry, but the ZBA no longer is necessary in this conversation. And it is not consistent when it is part of this conversation. and it's confusing and oftentimes causes a lot of perfectly fine applicants to lose tens of thousands of dollars in waiting. And to be very frank, sometimes it comes down to very personal. People just don't want it and have been against the legalization of this industry. And they see that ZBA as their last shot to finally stop it from coming to their neighborhood. And that's not the ZBA's job. So I'm going to turn this now over to Chris English, who is from ISD. He can speak a little bit about the zoning amendment, and then I'm going to open up for brief questions from counselors. And then we have, again, some people who signed up for public testimony, including Gabriel Camacho, Desiree Frangel, Elliot Laffer, who is the chair of the Neighborhood Association of the Back Bay. Gabriel Camacho, is from UFCW Local 1445, and Desiree Frangel is an equity applicant. So Chris.
Counselor, thank you, and thank you for having me. My name is Chris English. I'm the Chief of Staff from the Inspectional Services Department. I'm just here today to offer I don't really have a presentation or anything, but the opening of a cannabis establishment, the process itself is inherently tied to ISD's internal permitting processes, as well as the cannabis boards, and we're attached at the hip from the start to the finish there. So I'm here really to answer any questions you have about the process. I don't want to take up too much time by making any large presentation, but just to say that all applications for opening a cannabis establishment do require a long form permit application to change the use and occupancy of a property. Requires a whole set of construction documents to be submitted to us. We review for compliance with the building and the zoning code. And in all cases currently where cannabis establishments are not allowed, those applications are automatically denied and must go through the ZBA process to obtain a variance and or a conditional use permit for that use in that particular location. So that process, we utilize the timing for those hearings consistent with how the Cannabis Board also schedules their hearings in a particular order. The community process is done in conjunction with the Cannabis Board process, and we do not schedule a cannabis application before the Board of Appeal until we receive notice from the Cannabis Board and from Neighborhood Services that community process has been completed. So then we send them to the board, and that's how it rolls. But at risk of overstating the simple, I'm just here in case you have any questions about any part of ISD's or the ZBA's administrative process.
Thank you. To the councils that are on, we have some really actually good community testimony. Would it be okay if I actually just went ahead to them? Again, while Leslie's still here for the hour. Councilor Flynn, are you okay with that?
Yeah, I'm okay. I just wanted to ask Chris that one question about the South Boston site. If it's not a problem.
Not at all. No.
Okay. So Chris, can you explain to me and my constituents why are we doing a revote on the K Street site after it was determined that the board voted against the proposal? I'm against it. I know Councilor Flaherty is against it. The residents are against it. And then it was voted against, denying it, and then all of a sudden we're doing a revote. What's the reason?
So, Councilor, in that instance, it's not a revote on the application itself. The applicants during the actual hearing raised some concerns about, it sounds like, from my understanding, some technological difficulties. They are asking the board for approval for reconsideration. So the rehearing is not a hearing of the whole application itself. What they are asking for is approval to be reconsidered by the board in light of those challenges.
Chris, then it's my understanding if they were allowed to have another hearing, then they'd have the hearing on the same day, and then a vote would take place at the same, at the same time, basically.
It's not a defined thing. The board could say, sure, we'll bring you back for a hearing at a later date. That's up to the board.
But also they could have it at the same time at the end of the day, which is next week. So my constituents are asking me these difficult questions, and I don't like to be unprepared and not represent them effectively. We had a vote and ZBA voted against it, and now we're coming back for reconsideration. And if the board decides to reconsider it, we'll have the hearing again that day, and we'll have the vote that same day.
So I appreciate the back and forth, and I do think these are fair questions, Councillor Flynn, specifically about that. I think all of the city is wondering why and how this got rescheduled, and honestly, we're all wondering if this could happen in any one of our neighborhoods. Because of our time crunch, Councillor Flynn, if it's okay, on this specific case of this South Boston and its reconsideration, if we can table it while we have Leslie, and then we'll go to the ordinance and okay, I see you nodding. Thank you.
Yeah, thank you, Councilor Edwards, and thank you, Chris, and thank you, Leslie. I appreciate the hard work you guys are doing.
Thank you. Okay, so also who's also joined us as speakers is former City Councilor Mike Ross, and also Joe Ruggiero, who is not at all in any way, shape, or form speaking on behalf of the ZBA, but he is a member of the ZBA. So I am checking to see if Elliot Laffer, and I apologize if is available. And then Gabriel, Camacho will speak after him, and then Desiree. So I'm just calling those folks in. Let me see if you're on the, okay. Then I don't see Elliot.
Here I am.
There he is. Okay. Go ahead, Elliot.
My video to line up with your system. Hi, I'm Elliot Laffer. I'm chair of the Neighborhood Association of Back Bay. Let me join everyone else in wishing Leslie a quick recovery, and she shouldn't try to sign up for the Red Sox just yet. They seem to be doing okay without her. I want to speak to this, and Madam Chair, and I have a concern with the proposal. And the concern is that the board, which I think is the Cannabis Board, which is a very diligent board. I've had the privilege to appear before them, I think, 3 times now. They clearly take very seriously what they're doing, and see that a big part of their role is the establishment and promotion of this new industry in the city, which I think it is a big part of their role. The Back Bay and other downtown neighborhoods, but I can only speak to ours, is perhaps a little different than some others because we are very, very close to the commercial district. I live in a building on Commonwealth Avenue. I've lived there for 47 years, I think. And if you cross the alley, you're in a commercial district. And if this is an allowed use and a distributor wanted to go across the alley from me, which is 15 feet from my house, that would be something that I would have less of an opportunity to weigh in on, not necessarily oppose, but weigh in on, than I do if it's a conditional use. Because of the significant impact that they can have, liquor stores, which I analogize, if that's a word, liquor stores and marijuana dispensaries is very similar operations, and liquor stores are a conditional use. Restaurants are a conditional use because they can have more impact than a typical clothing store, let's say, or the retailer. And so the opportunity to weigh in on these is very, very important. And that doesn't mean we wind up not opposing probably 90% or more of those that we see. And we, in fact, didn't oppose one dispensary that came to us on Boylston Street, and we expect not to and didn't oppose at the Cannabis Board and expect not to oppose at the Board of Appeals, a second dispensary that came in front of us. We did oppose the one that was defeated at the Board of Appeals last week, and which had been approved by the Cannabis Board in spite of the fact that it is directly adjacent to an apartment building where the people were very, very opposed to it. I think that the boards have different missions. It's also not clear to me what the appeal process would be from the Board of Appeals. If you are an abutter, that's a tough challenge to meet to be an abutter. But if you're an abutter and have legal standing, you can go to court to challenge a ruling that you think is not appropriate. Not sure how you would do that coming out of the Cannabis Board. One of the Cannabis Board members said that well, we see opposition from the neighborhood, but we typically see opposition from the neighborhood. It's just people who think that maybe the industry is a good idea, but not where I am. And that's not what we did. And I found that distressing when they didn't note that we didn't oppose someplace else. So the messages don't, or the missions don't particularly line up between the two boards. And I think that this is right now, what exists is not that different from what exists in the alcohol regulation, which is a similar legal product. So I'm concerned that we'll lose some benefit. I understand the concerns about the Board of Appeals, and I've been dealing with the Board of Appeals on issues for a very long time, and it's certainly not perfect. But then very few of us are. So I raise those as concerns with all respect to the job that it's doing. And I'd also note one other thing that impacted on that first case in East Boston, which was clearly ludicrous, is looking at these in isolation. And that's actually what's happened here in the cases we've dealt with in the Back Bay. We get each one at a time. And if we go and say, well, we know we have another one coming next week or 2 weeks from now, no, we can't consider that's coming because we have to consider this one. And if we consider the second one better than the first, now we have a problem, and how do we express that? And I think that that's not dissimilar to what you ran into at the Board of Appeals on that first case before the Cannabis Board existed. So I'm not sure that this change gets at that issue because applications still get heard at the Cannabis Board one at a time, and they're going to hear whichever one gets there first in the way that they set up their agenda. They're not going to sit and listen to 4 or 5 of them and say, well, we like these 2 or this 1 or whatever within this buffer zone. Hope I haven't spoken too long, and I hope that's clear. And if you have questions for me, I'm happy to answer.
Thank you. Thank you so much. I'm going to go ahead and let Gabriel Camacho and Desiree speak. And then we, hopefully we still have Leslie for a couple minutes. I know I would love to also get an answer to the appeal process from the Boston Cannabis Board, or what standing abutters would have. But we're going to go now to Gabriel.
Good morning, City Councilors, President O'Malley, and Chair of the Government Operations Committee. My name is Gabriel Camacho. I am the Political Director of United Food and Commercial Workers, Local 1445. We represent 14,000 essential workers throughout the Commonwealth. You may know us in Boston as the faces of Stop and Shop, Macy's, TD Garden, and more recently, the cannabis industry. UFCW represents over 10,000 cannabis workers throughout the nation, and in Massachusetts, Local 1445 represents hundreds in grow facilities, manufacturing, processing, packaging, consumer service, and delivery, all under union contracts with union pay scales, benefits including pension plans, and union representation for this mostly younger workforce. Since cannabis is a more than $1 billion industry in Massachusetts, these workers must have union protections. As well-financed national cannabis companies are swallowing up smaller producers, it is imperative that these jobs have institutional security of the United Food and Commercial Workers, especially if we are serious about maintaining equity in the industry. As you know, union jobs have been a historic and systemic way of combating institutional racism. Indeed, union jobs have been a path to the middle class for people of color, impacted communities from the war on drugs, and immigrants like my late parents. It is for these broad social and economic justice reasons we support the amended language as indicated in Docket 0654. Specifically, we agree that after going through a gauntlet of procedures and receiving approval from the Boston Cannabis Board, an appearance before the Zoning Board of Appeals is an undue burden, especially for smaller, underfinanced companies. We also support making the distinction between retail and delivery companies, and that the equity ratio apply to retail and cultivation licensees. The Boston Cannabis Board is uniquely qualified to determine whether specific circumstances and conditions merit reconsideration of the proximity regulations as amended in section 8-13.6. We agree with the criteria for evaluation of an applicant and would only add that criterion number 2, employment plan, could be stronger by adding a labor peace agreement as it's indicated in page 4 of the Boston Cannabis Board scorecard. Thank you.
Thank you so much. So do you have some proposed language for that scorecard, or would you like to send some over?
I will forward that to you and other city councilors by the end of today.
Appreciate that. Thank you. Desiree Franjo?
Hello, everyone. How are you?
Good, thank you.
So yeah, I mean, I'm here today. I'm very well invested in the cannabis industry. I have been since the laws were passed. I'm a lifelong resident of Boston. My grandmother worked 35 years selling food out of her house, baking and cooking. My mom has worked 2 and 3 jobs for over 40 years. We've worked really hard, to be able to own our own property here and to be able to overcome the challenges that minorities have to overcome growing up in the city. And so, today I'm here after a few years of helping another social equity applicant, Massachusetts Citizens for Social Equity, in their community process to attain 3 HCAs. It really made me aware of how, the zoning around these cannabis properties are affecting us. We go through so many barriers just to even find the property, to build the capital, and the zoning process that we're having today, where, the ZBA has to give the final approval. It's really, I think, harming social equity applicants. So yeah, that's something I would love to see changed. I feel like, they were needed at the beginning, and now we have this great, cannabis board. I think that we have a lot of counselors and city officials like Ms. Edwards and other city counselors that are doing, a great job at making sure that this industry does benefit the people that were most affected. And that's what I would love to see for the city. I'm looking forward to being able to tell my daughter these stories in about 30 years and just highlighting how all these great people were on the right side of history. So, I think right now we're facing enough challenges as social equity applicants. I'm now applying for a location, and that's going to be a huge challenge for me. I have my whole family invested in this. We've all put our capital together. We've, worked very hard, and it feels like, this is everything's coming to fruition now, and having the ZBA removed from the process would definitely make our lives easier and you know, not feel like we're investing all this money to be shut down by you know, residents who have the financial resources to kind of fight you at the ZBA level. So I thank you guys for giving me a moment to speak today. I'm just really happy to be here. I'm very grateful for my city, for the councilors, for the Boston Cannabis Board, and for all these social equity applicants who are not giving up and are just trying to follow their dreams regardless of the barriers thrown at them. So thank you for your time today.
Mute. I'm on mute. I'm wondering why no one's doing anything, and because I talked to nobody. I apologize. So I said we have Leslie for about 10 more minutes, and then I wanted to go to Joe Ruggiero and Mike Ross, who are also signed up. And if you could, you know, quickly answer some questions, Leslie, and then we can have them also testify. Maybe you can stick around for theirs as well. Go ahead, Leslie.
Absolutely. So the question about what the appeal process would be, this is an administrative board just like the ZBA, so it's the same legal standard that the relief would be in Superior Court, and it would be the same as an action appealing a decision of the Zoning Board of Appeals. So there's no separate process. And what when a local licensing authority, in this case it's the BCB, allows an applicant to move forward with the state process, the Cannabis Control Commission look at very different criteria. They're really looking at your background checks, at your financials, at your security and operations in terms of your vaults and your locking mechanisms and things like that. So the appeal would not be to the state agency. It would be in Superior Court, just like it would be with the Zoning Board of Appeals.
Thank you very much. So we're going to go to, I think it's Mike Ross, then Joe Ruggiero, and then we'll have Shane Hyde speak after that.
Hello, Madam Chair and members of the council. Good to see you all. My name is Mike Ross. I'm a land use attorney at Prince Lobel. I want to thank the council for your leadership in this area. The first, the buffer legislation that Councilor Flaherty put forward, the equity legislation that Councilor Janey and yourself, Madam Chair, put forward, and now this. I think it's a good natural next step. And I, as a former city councilor, I appreciate the public policy initiative by the council. I think it's the most important thing you can do. And I think good public policy is very important. And I say good public policy as an attorney who will, not be, if this is successful, appearing before this board. So it's probably financially not in my interest to support this legislation. I will not be in front of the zoning board for cannabis, but that's okay. I think it's more important to have good public policy, and I really think this is where you should be going on that. So, the background you've heard in 2016, Massachusetts voters voted for this. The legislature adopted it. Boston voters voted for it. And in some communities, that vote was upwards of 70% and higher. And despite all of that, opponents have figured out, and cannabis is a controversy. It's still controversial. We're like in 1934 right now with alcohol. It's the equivalent of that when alcohol was prohibited in the United States, I believe. A group of 10, 20 residents have figured out that you can just show up at the Zoning Board of Appeal and kill something. And that's essentially what's happened. So far, about 10% of the applicants that have been approved by the Boston Cannabis Board, that have then been approved by the CCC, that has then had, in terms of provisionally approved, then had a host community agreement signed, a binding contract signed between the city of Boston and the entity, and spending, I would say, not tens of thousands of dollars, Madam Chair, but anywhere from, my estimate is around $250,000 to $1 million, then getting to the Zoning Board of Appeal only be told that it's not going to happen. The intent of the state legislation was to, quote, control the production and distribution of marijuana under a system that licenses, regulates, and taxes the businesses involved in a manner similar to alcohol. And that's not what's happening here. The sale of alcohol only requires zoning relief in certain parts of the city. The sale of cannabis requires zoning relief in every part of the city. You need a conditional use permit. And I think the looming issue here is that the Zoning Board of Appeal is denying conditional use permits, not because of the statutory requirements of why they should be denying it, if that's the thing, but because of this bias that occurs when the residents show up. I'm an attorney, you're an attorney, Madam Chair, so is Councilor Flaherty. I know Attorney Hawkins, who did a great job today, is an attorney as well. There might be others. But the seminal case here is Crittenden Hastings House in the appeals court in 1988, where Crittenden Hastings House provides abortions, and they wanted to open a nursery, which required a conditional use permit, just like cannabis requires a conditional use permit. Neighbors got together and they opposed it. And even though that the applicant presented data to the board that cured the traffic issues and the other issues, the board voted against it. And the appeals court overruled and overturned that decision in 1988. And they said it was arbitrary and capricious, that it was clear that what was happening here is that there was bias due to the underlying, in this case, abortion. But now we're seeing that happen here with the issue of cannabis. And so the problem is you can be denied by the board and then make the case statutorily that you were incorrectly denied, but you know what, you're out of luck. Now you're a year or 2 years down the road, some judge somewhere says, okay, you were right, the board was wrong, and you're gonna now get your license. But by then, Philip Morris has already moved into cannabis, and these entrepreneurs are shut out. In the end, this just simply comes down to fairness. I mean, there's a role for elected officials in this. They can mediate issues around hours of operations and logistics and how these things can work. But simply because someone doesn't like cannabis is not grounds for shooting it down. I heard that this was being analogized to losing or winning a hockey game. This isn't a game. These are established rights that have been codified in courts over decades, and people have a right to go forward and open their businesses. It's not about winning or losing a game. It's about preserving fairness, case law, and allowing good public policy to go forward in the city. So I'm happy to answer any questions. I obviously feel strong about this. I'd also say, Madam Chair, you have a lot of ability to finesse this. There are certain things that could stay at the Zoning Board of Appeal in terms of, you could have the buffer zone stay, you could not have the buffer zone stay. You could, there's a lot you can do here. And I think it should hit all the things that your colleagues want. I'm just glad you're doing it. And it's, again, hats off to you. You're doing some great things over there, and appreciate the opportunity to come in and say hello.
Thank you. Joe Ruggiero, then Shane Hyde, and then Ryan G. I see you lined up. Go ahead, Joe.
Well, it's just at 12 o'clock, so good afternoon, Madam Chair, members of three members of the council. My name is Joe Ruggiero. I'm a small business owner in East Boston. I happen to serve on the Zoning Board of Appeals, but have I'm here today as a public resident of East Boston in support of Councilor Edwards' text amendment to the zoning code, which would make cannabis establishments an allowed use in zoning districts that already favor business uses. The docket today, I think, will help streamline the issuance of cannabis licenses. It will put the experts in the field at the helm of deciding where these establishments should be licensed and which companies are the ones that we want doing business in our communities. As mentioned earlier today in the hearing, it is it's very rare that 100% of the wards in Boston agree on something. And that's how the vote broke in 2016, where every single ward in the city, 95% of the precincts voted in favor of recreational use cannabis. And as previously mentioned, it's tied to liquor licenses in that legislation, and liquor licenses, liquor distributors, package stores, things like that are allowed in certain business districts already under the zoning code. So at bare minimum, it should at least mimic that, if not everywhere in business districts. Since that vote, it seems anti-marijuana advocates have been given repeated opportunities to swing and exert their will over the will of the voters. I don't think the intent of the countless community meetings and abutters meetings and council hearings and zoning hearings and cannabis board hearings and all the other endless gatherings of residents and stakeholders ever thought that would be what would happen, but that seems to be the unintended consequences. If you attend any of these meetings, and I was a past president of Orion Heights Neighborhood Council, you see that very clearly, that the stigma of marijuana use is alive and well. I would like to just point out that I myself don't consume marijuana. I'm a person in long-term recovery. I haven't had a drink or a drug since July of 2009. So this is no like personal stake for this at all to me. It's just the right thing for our community, I believe. From a land use perspective, these establishments are legal businesses in the Commonwealth now. They should be able to operate where other businesses operate. It's a highly regulated industry. Very few other industries that I know of have as many stringent state and local guidelines on where to operate and how to operate. Requiring a conditional use permit is just repetitive and frankly overburdensome. The current process is so arduous that in fact it just perpetuates the inequities in this industry. The endless run through of community meetings, it gets expensive, as previous testimony has alluded to. The additional step of obtaining the conditional use permit, it can cause a small local business to fail before it even has a chance to open. On the other hand, the well-funded corporations will absorb this additional expense and come through the other side triumphant. And that's just, it defeats the whole purpose of the equity, of equity in this. We also have business districts that could use a boost, that have vacant storefronts, that have been felt the squeeze of the pandemic, of the changing economy. And these businesses can be seen, it should be seen as a way to boost these empty storefronts, to get businesses back into our communities, to get the neighborhood shopping districts off their feet again. And not all these business districts are within a half mile of each other. You know, the case in East Boston, Central Square and Maverick Square are very different places. If you talk to two residents, they're just very different places. And what's happened is this measuring game of where a half mile ends and where it doesn't end. And not all half miles are equal. Some half miles in Boston have 100 or 1,000 residents. Other half miles have tens of thousands of residents. And those things need to be taken into account. The will of the voters was very clear on this on the legislation. Stringent legislation has already been enacted. A simplified process can also be transparent and can hold the applicants accountable. And I think this is one step to getting us there. Thank you for the time today.
Thank you, Joe. I'm just going to say that was very powerful testimony. And thank you for bringing up your recovery. Thank you for, in general, everything that you just said. I think I'll quote you going forward. Not all half miles are the same, which is true. Thank you. I think Shane was next. Shane Hyde, and then I had let's see, Brian, and then Maria Maloney or Malone. I apologize if I mispronounced your name. Go ahead, Shane.
Thanks, Counselor. Yeah, my name is Shane Hyde. I'm a CEO of an equity applicant here in Boston. I want to thank the council for giving me the opportunity to testify today. I really just want to quickly touch on my experience with the BCB and offer them their due praise and how they've approached this new industry here in the city. As a board who's immersed themselves into the industry since they have been founded, they have shown that they've probably considered like all the aspects of cannabis and what it would mean for particular occasions in the city. And they're also willing to work with applicants such as myself to improve operations and business plans to make it the best possible application possible. And as someone who's worked with other municipalities across the Commonwealth, this is something that just hasn't been done. And so the fact that that they are working with the applicants, the fact that they've immersed themselves into the industry, this is how it should be done, rather than say at a mayor's office or a select board or something who just see this industry in passing. And so putting the decision-making power into the hands of those experts who have taken time to understand the industry, I think is a really, really good and imperative for the city. Just quickly, just want to, again, thanks to the Boston Cannabis Board and Leslie for all the work that they've done. I hope she enjoys her vacation. And thanks again for the City Council in setting up and enacting this board, which I think is a great example for across the Commonwealth and for some of these other metro areas that will be coming along the lines in terms of legalization, states that are now on the precipice of getting where Massachusetts was 3 years ago. And I think, as obviously the Boston, the heart of the state, those are what those other big cities are going to look at. And so setting up councils like this, I think it's just setting a great example for the rest of the country moving forward. And, there's been hiccups and whatnot, in California with LA and how they've done things. And now they're coming around to doing what Massachusetts was doing what Boston is doing, and putting the experts and those who understand the industry in charge of deciding which businesses should move forward and which ones should not. So thank you again for the testimony. And again, I think it's a big supporter of change. Thank you.
Thank you. Just want to note we've been joined by Councillor Andrea Campbell. Councillor, we're going through some public testimony before we go back to the councillors. I don't know if you had a brief hello for folks, but then after you, I want to go back to public testimony.
Oh, no, thank you, Councillor Edwards. Sorry, I'm late at another conflict, so we'll review the tape and listen to more public testimony and stay in contact. Thank you.
Thank you. I think I had Brian and then Maria. Oh. You're mute. For some reason, we can't hear you, Brian. And I'm sorry, I would have just, you're speaking on behalf of the BPDA, correct? Okay, so I can't hear you. I apologize. I would have just had you go with the rest of the administration. So this is Brian Glasscock from the BPDA. You're gonna reboot. Okay, we'll come back to you. We're gonna go now to Maria. And then after Maria, I see that there's a Ron and a Jeff, Ron Lipoff or Ron Lipoff and a Jeff. And then that would be our public testimony that I have, that I see right now. Okay, Maria?
Thank you. Thank you so much for this time today. To be honest, I literally found out about this hearing 15 or 20 minutes ago, so I don't really have very well prepared comments. However, I have been involved with the process for the licensing of an establishment. I am a resident on East First Street in South Boston. And the first thing I would like to say is, we keep hearing about the fact that we voted for cannabis, and I will say I did vote for the legalization of cannabis. I did not vote for the number of establishments that is being asked to be placed within the city of Boston. So I think that's an important distinction to make. In terms of the Boston Cannabis Board, I think that the experience that myself and my neighbors had was less than ideal. The hearing that we attended, we got very short notice of the hearing. We were not able to really prepare for something that was going to be significantly impacting us. And, we're really treated quite dismissively, even though I think we had some very reasonable concerns. I feel that the board really didn't put the applicant through any real stringent questioning or credentialing of information that was presented to them. In fact, after the hearing, we were able to get their detailed presentation materials that were submitted, and we found a significant number of false statements. It was kind of thrown in our face that the applicant had a certain amount of support, when in fact we have found that some of their supporters gave invalid addresses. Anyway, just to say that, we didn't feel as a neighborhood that really there was any credentialing of the applicant, really felt that the process was very much a rubber stamp process. I think if the Boston Cannabis Board is going to be given any additional responsibility, that needs to be better clearly defined. And I think potentially there needs to be a different process for determining who the members of that board are. In our particular case here in South Boston, having the applicant have to go to the zoning board is not simply because of cannabis. Our current zoning regulations prohibit, or I shouldn't say prohibit, but having a retail establishment in our neighborhood is a conditional use. Any retail establishment. And I think it's important to continue to, be able to protect the regulations, the zoning guidelines that were so arduously written, just back in 2011 to protect the residential and local industrial aspects of our neighborhood. And if we did not have this step of going to the ZBA, we wouldn't have the opportunity to protect our neighborhood in that regard. So again, I thank you for your time today. Again, I apologize that my comments weren't well thought out, as I didn't have advance notice of the meeting, but I strongly encourage you to seriously consider making any adjustments to the Boston Cannabis Board's current responsibilities and purview. Thank you.
Thank you very much. And just your comments were perfect, first of all, and I appreciate that. That's why we go to the public, to hear directly about the impact of decisions that we are potentially going to make, and for you to push or move our decision-making in language. So number one. And then number two, if you want to just send an email with some bullets that maybe add additional suggestions, that's where also I'm going to recommend this at the end of this, because we will have a working session where we go into the language. And so it'd be great to get some suggestions from you as well. Thank you so much, Maria. So I think I had, after Maria, I mentioned a Jeff and a Ron Lipoff. I see Jeff on screen so go ahead, Jeff. You can unmute yourself and turn your camera on, please. Or unmute yourself. Let's see if I can. I just sent a request to ask you to unmute. Okay.
Yes, thank you.
Okay.
Thank you, Councilor Edwards. I'm not sure if you can see, or can you hear me?
We can hear you. We cannot see you.
Okay, I apologize. I was just informed of this and decided to jump on for just a quick minute. I listened to Mike Ross, who spoke on behalf of cannabis owners, and all of us that have gone through or are going through this process. And I just wanted to say that I just listened to the young lady speak, and she like many people that are against these establishments going into their communities, voted for cannabis. They vote for cannabis, but they don't believe they should be in their communities. They believe they should only be in Dorchester or Roxbury or communities such as those. And it becomes problematic. As Mike Ross said, when 70% of a community votes for cannabis, but 20 or 30 people come out against it, that's expected. There are a lot of people, me included, who do not smoke cannabis. There are a lot of people in South Boston, for example, that are part of a recovery community that do not smoke cannabis. They don't drink. But they can't be exempt from cannabis being sold in their communities. It was voted for statewide. It's voted for in the city. There are going to be 52 stores in the city. And the majority of the reasons that they are against this is traffic and crime and so forth. All of those have been mitigated by stores already opening up. Netta, which had the highest gross sales in the country, everybody wants to use as an example. There are no more lines out there. There's no crime, there's no traffic issues. And as 52 of these open up over, I believe there's only a half a dozen of these already open. I believe as these continue to open up, they're going to be as local liquor stores are. And so it doesn't help if you have a conditional use to go to zoning and find out that the 20 or 30 or 50 people that are against cannabis fight you, where 70% of your community has voted for this, and they stop the process. So I applaud you for bringing this to everybody's attention. I applaud both the Cannabis Board, the zoning board, the city councilors, Councilor Flynn, Flaherty, and all the others in addition to you for looking into this issue. And I support the process going through the Boston Cannabis Commission. Thank you very much.
Thank you very much. Brian Graves, and then we've been joined again by Brian Glasscock from the BPDA. Brian Graves.
Yes, good afternoon, everyone. Thank you so much. My name is Brian Graves. I'm a resident of South Boston. I live at 503 East First. And my neighbor Maria just spoke a few minutes ago. I'd like to clarify a few items that Jeff and former Councilor Ross had opined about. For our particular process, we have 208 abutters today, 260 South Boston residents who are opposed to the location. We're not opposed to cannabis, but we're opposed to the siting of a large-scale retail operation that, by their own accounting, would generate 783 car trips on a street that had traffic increase by 72% by BTD's own data. This particular applicant had not done the work around traffic to explain to the community exactly how much of an impact it was going to have, and we've had to dig for this information ourselves. I would note that 10% not approved by the ZBA means that 90% were approved. That means the vast majority of those that the VCB granted licenses to were approved by the ZBA. The mission of the ZBA is different than the mission of the VCB. The ZBA is there to look at, follow, interpret current zoning. And in South Boston, as Maria mentioned, we have Article 68 that was approved through an arduous process, something like 12 to 18 months in 2011. And for those items that are conditional use, then refer to Article 6. So Article 68 does not is not as of right, on the side of the street where at least our cannabis shop had been proposed. it is not as of right to put retail there and not large scale retail. We very concerned about traffic. N Street just had a recent tragedy in the neighborhood. I think Councilor Flynn has been a huge proponent of traffic and safety in the neighborhood, and we appreciate his support. But this large-scale cannabis dispensary in our neighborhood is not what we voted for when we voted for cannabis. Put it up on East Broadway. Put it along Pappas Way. There are places in the neighborhood where it can be supported, and we would support it. But don't let people tell you just because we're opposed to their particular cannabis dispensary on our street that it's it's us opposing cannabis in our backyard. It's not. It's safety. In fact, Article 6 says no adverse effect on the neighborhood. So for conditional use, no serious hazard to vehicles or pedestrians, no nuisance. Those are all things that when the ZBA, I believe, voted 6-1 against the proposal here, took into consideration the 208 abutters that were opposed. And thankfully, they're protecting our interests. I think the BCB having control of all aspects of the approval and citing would be too much in one group's hands. And I appreciate the fact that the ZBA weighed in, they listened to our feedback, and they voted.
Thank you very much, Brian. I did have a couple folks wanted to respond, I think, to Jeff's comments, specifically some aspects that felt they were mischaracterized in their testimony. And I just want to say, at the end of the day, today's conversation, which is what we're having, we shouldn't make assumptions about people's, why they stand where they stand, what they're doing, what's in their hearts, or what they feel. They're testifying in good faith about something that is controversial, about something that is a massive change. It's a permanent change in their neighborhoods. We're not going to assume that they do so with bad faith, that they don't want it in their neighborhood, that they're being a NIMBY, and so on and so forth. So I just wanted to cleanse that. And if any future testimony, public testimony is going to do that and make assumptions about people's hearts, minds, expectations for their neighborhoods, then I'm going to shut it down. Thank you. Now, in terms of other folks to testify, so Maria, I hope my response was okay. I really tried not to have back and forth between folks and just keep it on the issues, but I did want to acknowledge that concern. I think that is, Brian Glasscock from the BPDA.
Councilor, thank you. Hopefully I'm up and running this time. Not a whole lot to add here, except thank you for taking this on. This is a super tough issue. I was involved in drafting the original zoning language when it was medical marijuana only, and then the move to retail. And we struggled with all the things that you've touched on today at the time, but we didn't have the cannabis board at the time to really know, it existed conceptually, but not as an actual entity. So we weren't really sure how this was going to work out. And I think that the science of government sometimes is a science of experiment, and we've learned a lot in that interim. I think Chris English, nailed it early on. We had talked to everybody else in the country that was doing this, trying to get, learn best practices, learn lessons from their mistakes. And the two things that we came away from it was you don't want a green mile situation, and you want to have some control over the advertising, because the advertising, the competition through advertising just sort of turned it into sort of a circus-like atmosphere, and that wasn't good. So, I think we've done pretty well with the advertising piece. You don't see anything that's, really over the top. And I think the green mile issue, the thing that we were trying to balance was not only, we want to balance the benefits that could come to communities of having these things. We also want to balance the burdens. And we thought there will be neighborhoods that will be left behind that won't have a dispensary in it if there aren't some isn't some mechanism to sort of push them apart. And I think that's largely happened. I think we're seeing dispensaries in neighborhoods throughout the city. There's a fairly good distribution, and it hasn't turned into Green Mile. So, maybe it's the time to pivot. Our agency hasn't taken a position on this, but we stand ready to work with you. Whatever changes to zoning need to happen to sort of move into the next phase. But we think that it does represent an opportunity, for neighbors to both benefit and then to equally accept some of the burdens of this new and emerging industry. And so just offer our assistance however we can be helpful.
Thank you very much. So Chris English from ISD and Brian Glasscock from BPDA, at this point, there's no, I'm assuming the administration or your agencies have no opinion about it. You just will work with us with what ends up being the final product. Is that what I'm hearing?
Yeah, and as you know, the BPDA, anything that we bring forward as a zoning amendment, we generally run through the BPDA board first.
Right.
That process, they make a recommendation to the zoning commission. So there would be sort of a process to follow here. What we've done recently is where zoning recommendations are coming straight from city council, we may be able to go straight to the zoning commission.
Right.
But it's always good if we can work it out, sort of timing wise, to get our board to make a direct recommendation to the zoning commission as well. But we'll work with you. I didn't hear in any of the prefatory remarks as what the time frame was exactly. I don't know that there's I suspect that there's not a deadline so much as that you want to move forward with this fairly deliberately. Because there are people waiting in the queue that this is impacting people, and they need, whatever the outcome is, they need some certainty as to what changes, if any, will happen.
Thank you. And Chris?
Thanks, Councilor. I just echo what Brian said and Leslie as well. We are a regulatory agency here, so we are the enforcers of the building and the zoning code. So we're not taking a position on this, but we're happy to work with you on procedurally and how to move forward.
Thank you. So I think I've gotten all of the public testimony, at least one round. I'm going to go back through counselors to ask any questions, and then I'm going to discuss next steps and what we plan on doing in this conversation. Counselor Flynn, then Counselor Flaherty.
Thank you, Council Edwards, and again, thank you to Chris, to Leslie, and to Brian as well, and to all of those that testified. Just for the record, I think I probably have 7 or 8 of these dispensaries in my district that I supported. And at least 2 of them are owned by, one's owned by a woman of color. I think it was the first equity applicant in the downtown area, actually near the North Station area, I should say. So my main point is I work closely with the neighbors, with residents, with the neighborhood organizations to make sure that there is a fair and open and transparent process. That's my job as a district city councilor. Like my colleagues on the city council, we take this responsibility very seriously. That's why we're here today, listening to the concerns of residents. It's not about not in my backyard, but it's about making sure residents have a fair and open, and that their voice is respected and heard at city government. So again, just want to say thank you to Councilor Edwards, to Councilor Flaherty as well, and all of those that testified, whether they agree with me or don't agree with me. That's democracy. Thank you, Councilor Edwards.
Excellent comments, Counselor Flynn. Thank you. Counselor Flaherty?
Thank you, Madam Chair. Just wanted to take this opportunity to underscore it's obviously the strengths, I guess, of the positives of the buffer zone in terms of it bringing about a level of predictability for proponents and those that are making a commitment and making an investment and or securing and putting together a team as to sort of where they can go and where they can't go. And predictability, particularly in real estate businesses, is paramount. It's huge. So that's one of the strengths of having the buffer.
Council Flaherty, you went out. Councilor Flaherty, we cannot hear you. I'm gonna text you very quickly, but I'm gonna go ahead and talk next steps and what and kind of answer some of the questions. I know that a lot of people have discussed community process and back and forth. I want to be clear that the Cannabis Board regulations requires a community meeting and then requires a letter from the district city council, which means a lot to me as a district city councilor, and I'm sure to my colleagues. The ZBA does not require that. The ZBA can look to us, cannot look to us, but we actually have more of a voice and are reflective more of the community as district city councilors because we codified a space for us in this process with the Boston Cannabis Board. That's a huge difference. I also wanted to note that the score sheets, you want to talk about transparency and process, the score sheets for the members of the BCB is available upon request. It may be available publicly. We had to file a home rule petition and then get an executive order, and we're still waiting to see what goes into the decisions of ZBA members right now. We're hoping to get that codified, and that's what we're fighting for as a community, to get the ZBA to even tell us what they consider on the current laws that they're supposed to be enforcing or granting variances to. We don't have that. So there are actually distinct, huge differences in this process, and I want to note the community is very much involved in the Boston Cannabis Board process. The board does not always agree with me as a district city councilor, I know, but I do feel heard at the Boston Cannabis Board. So I just wanted to note that. I understand people are not attacking the board, but people are discussing community process, and I did want to make sure that we were clear about that. Other things that I think are worth noting, by removing it from the ZBA and putting this conversation squarely within the ordinance concerning the Boston Cannabis Board, that is yet another opportunity for us to move faster, to adjust, to make stronger our regulations and our laws on cannabis by taking it away from the ZBA and putting it again in a different law. The other parts of the Boston Cannabis Board are controlled by and influenced by their own regulations, of which all of us can propose regulations to the Boston Cannabis Board to go back and forth. So I actually think that the opportunity for a robust conversation for making sure this industry is as equitable, fair, and safe, and has a home in our neighborhoods, all of our neighborhoods, is through the Boston Cannabis Board regulations and ordinance. And that's why, for those who may not have read yet, we did propose certain regulations for the buffer zone. The buffer zone still exists, everyone. It still exists. It exists in the ordinance. And then we came up with exceptions for that for the board to consider. That is what is also pending. And so what I'm hoping for is that the conversation will continue and become more robust in a working session. But for right now, the proposed regulations, if you want an exception to the buffer zone, include documentation of support, which may include letters from support from community members, letters from community organizations, direct and indirect butters, and elected officials. And you must receive a minimum 3 letters of support. That's what we have right now is one of the regulations if you want an exception to the buffer zone. Applicant's statement explaining, so the applicants must explain in particularity why the applicant should be granted a conditional license despite the proximity to another applicant. You have to address in that letter special circumstances or conditions that apply to this location, reasons for practical difficulty and substantial hardship, explaining why the proximity to another applicant should not prevent the BCB from granting the license, and how the Boston Cannabis Board's grant of a license would not negatively impact the surrounding neighborhood. So these are standards we are already proposing that they would have to consider before they can let you come within a half mile. Excuse me, not you, let one dispensary come within a half mile of another. So that's pending. And again, it's actually easier to move influence and adjust to this industry. And let me be very clear, this industry is going to change a lot. We're talking, I'm sure at some point, about having on-site consumption, restaurants, consuming, cannabis food on site. There's a lot of different ways in which this industry is going to change. We actually want to keep the flexibility. And I think the best way to do so is in the regulations and in the ordinance, not in the ZBA, who I don't think they can adjust as fast. So other things we will consider in the working session, which we will be planning, is adding in labor language or workers' rights. I know that was something that UFCW specifically was concerned about. We will look at the standards and we'll take any suggestions you have for granting exceptions to the half-mile buffer. And then also continually looking at delivery and other entities that may or may not belong with the 1-for-1. That is more of a regulation discussion, but still I think it came up with lab space and so on and so forth. So, and then just for clarification, we can very well then approve the zoning language, which just removes or creates the conditional use or allowable use, excuse me, and move that along. And it can go straight to the zoning commission, as Brian Glasscock noted. The BPDA seems to be neutral or have no real opinion about this yet. They would probably want the best product or best zoning language that's clear to move forward wherever it goes, to their board or directly to the zoning commission. And then zoning commission ultimately would have to make the decision to change the law. So that's one proposal. And I did want to ask Brian Glasscock, if you're still there. Hi. So assuming this amendment passes and goes to the BPDA, we file it with you. My understanding is if by virtue of it being filed with you, and let's say there's an advertised hearing for you, that those people pending, that they can withdraw without prejudice, or they could, there's a certain kind of cloak that they have if the zoning is changing while they're pending and waiting in line for the ZBA. Could you explain that?
Yeah. So the default position is if the zoning commission advertises a change to zoning, that new proposed zoning then becomes sort of the law of the land until the zoning commission either approves it or rejects it. So somebody who was in the queue that didn't have a building permit had not gotten the change of use permit yet through ISD, they could withdraw and refile and be covered under whatever the new proposed zoning was. The one caveat is if something happens and it doesn't eventually pass, they sort of given up their spot in the queue, and they'd have to start over again. But yes, you are correct that the default position, unless we say otherwise in the zoning amendment itself, the proposed new zoning applies to any project that doesn't already have a building permit. Now you're on mute.
Thank you. So that's then upon advertising by the zoning commission.
Right. The first advertisement for the hearing, it's sort of, and you can imagine why that is it would create a run on the bank. Ordinarily, when we're changing zoning, if it didn't apply to things, a lot of people would be trying to get in under the old zoning because we're not usually, making things easier for people. In this case, we're making it easier for people. So it's less of a problem, and it might actually help some people out. But I get that there's, while there's no hard and fast deadline, there is just some sense of urgency here because there are people, in the queue. There's the meter's running for a lot of people. They're paying carrying costs. They're, and rent and so on, and they're sort of tied up trying to figure this thing out. So, we more than anything, we want to give them some predictability. We hear that all the time from everybody from small business entrepreneurs to the biggest developers is to some extent it doesn't matter quite so much what the rules are, as long as they know what they are. They're predictable and they can work around it. So we want to make sure we're not sort of whipsawing people around by moving the goalposts for them. We want to give them some level of certainty that when we propose something to the zoning commission, that we have every intention and every ability to get that carried out. So, we will do our best to make sure that happens.
Thank you. Okay, I appreciate that. So unless there's any final remarks, I'm going to go ahead and end this hearing. Note that we will have a working session. My goal is to move a comprehensive compromise zoning amendment on this particular topic that does remove the ZBA, provided my colleagues agree, removes the ZBA, but in exchange for that, puts clear standards in the ordinance for the Boston Cannabis Board, specifically around this zoning, this buffer zone. We won't leave without having clarity standards that balance the needs of the neighborhood, prevent a green mile, prevent the concentration in any one neighborhood, and assures that, again, there's an equitable distribution of the benefits and burdens of cannabis in Boston. So with that, I'm going to go ahead and close out this hearing. Thank you very much. Have a good day.